The Senate Judiciary Committee, as always, we have sign-up sheets up front. If you want to be heard on one of the bills, please come sign up so we'll make sure I don't miss you. I'm going to ask Senator Kirkpatrick if she'll start us off with a word of prayer.
Thank you, Mr. Chair. Please pray with me. Dear Heavenly Father, thank you for another beautiful day in Georgia. Give us strength as we charge our way ahead through these last few weeks before crossover. And thank you for our freedom. And please be with those who are fighting for their freedom around the world. Let us not take our blessings here in America for granted. In your holy name, amen.
Thank you for that. All right, we will start with Senate Bill 499. Senator Tippins, we were working off of LC 393195, and the floor is yours.
Thank you, Mr. Chairman, members of the committee. I bring you Senate Bill 499. I've got involved in this bill as a result of a conversation I had with a gentleman who was retired as an assistant prosecutor for both the Solicitor General's office and the DA's office in Cobb County. Been a long time friend of mine, and he suggested that I look at this. And I told him, I said, I know very little about the law in this area. If you would do me some research. And so on this subject matter, I think he researched most of the states in the Southeast and was of the opinion that probably Florida had the strongest law in this, and this change in this law pretty much reflects how this is treated in the state of Florida. My concern that would prompt me to do this, I think all of us who have wives and daughters, we always have in the back of our mind what the effect of a sexual offense against them would be. And I think it's imperative that we expand a little bit the collection of DNA, given the nature of these type crimes and the repetitiveness with which it seems to happen. That most of these people are not one-time offenders, they're repeat offenders, and I think the sooner we get some evidence that we can go on in terms of trying to solve some of these cases, both current cases and also maybe even cold cases, would be in the public's best interest. In preparation of this bill, I just happened to across an article that was dealing with mass murders, and I noticed that one of the most notorious crimes in England was a man that killed and raped 32 women over about a 3.5 year period of time. He was arrested 7 times, arrested and questioned 7 times, and they never could get evidence that would substantiate his participation in this. And finally, they got evidence that was enough to convict him. Matter of fact, the first time he murdered a lady, his first rape and murder, he was questioned that very first case. And so I think it's in the public's best interest for us to build a expander DNA database. What this does is it expands it primarily with those who've been convicted of certain misdemeanors, and it also direct your attention to line 34, those who have been charged with a felony after a finding of probable cause for his or her arrest. I know this may be tough for somebody to swallow, but I think if you've got a wife or a daughter, or you're female yourself, to me, if there is probable cause, I don't see any problem with this. If they're exonerated, then I think we can expunge any of this, the data that's collected. But I do believe that that this has merit. I'll be glad to entertain any questions that you may have.
Do you know if any other states do this?
Pardon?
Do you know if any other states collect DNA like this?
Florida does.
Florida?
Florida's got a law that's enacted, and basically we copied Florida's law.
This is trying to basically copy what Florida has.
Right.
Any questions for Senator Tippins from the committee? Senator Cowsert?
Senator, this is a recurring bill. It's fourth or fifth time I've seen it in my service, and it continuously tries to request or require DNA samples from people that are not yet convicted. That troubles me with all the information, our genetic, code that is in our DNA now. I mean, everything from, your ancestry to what type of illnesses you may be susceptible to or whatever. It seems to be more personal to me than just solving crimes. And I'm troubled by us requiring people just because they're accused of a crime to have to submit to a DNA sample. I understand, conviction of felonies. Are there examples that you know of where DNA in Florida, wherever, that was taken from people before they were convicted of a forcible felony has been used to solve a crime or prevent a crime?
I can't speak to that, Senator. I share some of the same concerns about invasion of privacy, but I also know that for us to be able to go on the floor of the Senate, we had to split the test tube twice a week to get tested. I think that might constitute gathering of DNA samples, if I'm not mistaken.
Yeah. Well, I have made the argument in the past that if we're weighing a couple of different public policy arguments. One is the privacy of a person's own, makeup of their being versus the ability to solve crimes. I mean, if it's just to solve crimes, we ought to make every baby give us a DNA sample when we take their little footprint on the card. Then we'd have a database of everybody's DNA, would make crime solving real easy if there's DNA evidence. But
I don't disagree with that, but I would say this in reference to the collecting of the baby sample. There's no probable cause with the baby or anyone else who's not been arrested under probable cause. Y'all are all greater legal minds than I am, but I just think it's an issue we need to look at. I was not aware of the fact that we'd had 4 or 5 bills come before you.
one final question. Mr.
Yes,
Chair.
sir.
I'm looking now at lines 34 to 36, and that basically reads anybody who is charged with a felony after a finding of probable cause. It doesn't define these as just being violent offenses or.
Well, it should. I'm sorry. If
There's so many things.
I would not have any problem if you didn't want to, if you wanted to put some guardrails around it as to which specific crimes. If you'll notice in the misdemeanors, it stipulates those crimes that are most readily identifiable with repetitive sex crimes and the practice of that. Very seldom do you see anybody that commits one of these that are enumerated just one time. I would not be opposed at all to any amendment that you may want to do to rein that in. I'm not sure that everyone committing a felony needs their DNA collected, but if they're arrested under probable cause for one of these sex crimes, I think it would be in the public's interest.
Okay. Thank you, Senator.
Senator Rett?
Thank you, Mr. Chairman. Will the senator yield? Excuse me, I'm sorry, Senator. I just have a couple questions for you. I know you said that foreign country to the south of us, Florida does this, right? Are there any other states that do this that you're aware of?
Tennessee's got one. I think I don't know, the research in it. I think the fellow brought me 4 or 5, and basically I carried them to legislative council and asked them to look through it and to see.
I just have a small concern about the cost of collecting DNA samples from those accused of a crime and convicted of a crime versus just those convicted of a crime. And then when you talk, will we have to do this for people who are arrested for misdemeanors, like maybe selling loose cigarettes?
No.
You do the DNA?
If you'll read the misdemeanors, they have to be convicted only in these particular areas. you have a very, from line 38 through 45, any of those crimes that they have been convicted in as a misdemeanor, either as aggravated assault or just assault, or any of these. But in the line that Senator Cowser referenced was line obviously 34. And after finding probable cause in the arrest, I would not have any problem with having this same list of appropriate offenses listed that would be termed as sex crimes. I just think it's a protection. I think it would prevent repeat offenses, and even if it's a cold case, I think a lot of times families wrestle with getting closure. And I think in the case in England, had they collected DNA evidence the first time this gentleman was arrested, probably the second or third time he committed the offense, it would have probably pointed to him, but they had no valid permissible evidence. But I just, 32 women were raped and they lost their life in England. One individual that was arrested 7 times, but he was released because of lack of evidence.
Senator Watson.
So speaking of some of those minds that may not have the legal clarity that you profess, would you be receptive to maybe taking a look at this and limiting it to the sexual crimes?
Absolutely.
And bringing it back to us? Because I think that would better define it, and I think that's what you're getting at. And to do that on the fly, I don't think is probably the right thing to do. And I'm sure we got appropriate legal counsel that can limit that if you're receptive to that.
I'm absolutely, and I appreciate you hearing it. I appreciate your suggestion. I'll be glad to bring back
Your questions for Senator Tippins? All right, hold tight. Somebody else is signed up to be heard on the bill. Miss Maisie Lynn Girton, Georgia Association of Criminal Defense Lawyers. Good afternoon.
Good afternoon, Chairman. Thank you, as always, for hearing from us today. I am Maisie Lynn Girton, General Counsel for the Georgia Association of Criminal Defense Lawyers. I guess I'll start where you just ended, and with all due respect to Senator Watson's suggestion, unless these crimes are narrowed to being convictions, we would still stand in opposition. Because when you're taking someone's DNA, as Senator Cowser was mentioning, at the time of arrest, it's essentially as if we would take anyone's DNA in this room today. We are all just as innocent as every person that's charged with a crime in our state right now. And if we are going to start swabbing people who are innocent in our legal system, maybe we ought to swab them in our legislative system. Maybe we ought to swab them in our executive branch as well. I would also say, I'd like to clarify the fact that the probable cause called for in this legislation, and this is at line 36, is not probable cause related to the need for the DNA. It's for the actual arrest. So you may well have probable cause to arrest someone for felony shoplifting, but if that crime has no relation to DNA, you would never get a search warrant for it. We have a mechanism by which the police can get DNA evidence, and it's a search warrant. It's a judicial process. It requires due process. And that is the process that we should use for people at that stage of the game. Our concerns with respect to the misdemeanor charges, although they are convictions in the bill, is that as you look through this list, many of them have nothing to do with crimes that are directly related to DNA. I understand that there's likely an argument that these crimes are sort of gateway crimes to more serious sexual offenses that then would be covered under the felony provision. But starting with these crimes here that are, like, for instance, pimping. I mean, as abhorrent as that activity is, DNA is not necessarily going to help solve or convict someone of that particular crime. We believe this bill also has some concerns of constitutional import that you all should be aware of. You might realize that Georgia's Constitution is in some ways much more protective even than our federal Constitution. And we have concerns about the right to privacy that is potentially invaded in this bill. For instance, we know that you have to have a compelling state interest that's narrowly tailored to promote only that interest when you want to invade someone's privacy. We also have concerns about the unconstitutional self-incrimination that could be available through this policy. We have several cases that have come out of our courts in recent years: Elliott, Olevec, Awad, and these are all related to the scope of paragraph 16 in our Constitution prohibiting self-incrimination. And it has been extended in those cases to things like chemical testing in the DUI scenario. Under the reasoning in Olevec and Elliott, the court held in Awad that the right against compelled self-incrimination that's protected by paragraph 16 prohibits the state from admitting into evidence the defendant's refusal to, in this case, urinate. It's plausible that the reasoning that's been applied in those cases could be extended to this bill as well. Whenever we see the goalpost being moved so that this body is infringing on rights prior to a conviction, an alarm bell goes off in our mind. It's imperative that you all can keep in your mind the fact that our Constitution does recognize innocence until our guilt is proven. Someone actually remarked to me earlier today, you realize what we're creating here is a database, right? There's a database where this information is held. And the only mechanism by which one of these individuals who, upon arrest, had their DNA taken, the only mechanism for them to get off of this database would be through an acquittal, as I read this statute. It is a serious, serious bar. It's also a serious load on the judiciary, because that will definitely cause more people to go to trial. When I was talking about this bill in the hallway earlier today, someone remarked about how we've heard in the different gun bills that are being considered this session, we've heard people bringing up the idea of having databases for tracking guns in our state, and it has been strongly rejected. And yet, we want to create a database of innocent people's DNA. It just seems very, very dissonant to have these competing conversations under this dome this year. And again, this is the situations we're talking about where someone has not yet been adjudicated guilty. We understand that the current law does allow someone convicted of a felony to suffer this sort of invasion under our current law. We're not challenging that. Just don't want to go too much over things that are rehashes, but I'm going to make sure I get everything that you need to hear. There has been a finding in the U.S. Supreme Court, it's a 2013 case called Maryland versus King, that does acknowledge that a felony arrestee, the DNA collection from that person was constitutional under the Fourth Amendment. Interestingly, Scalia offered the dissent in that case. And if I can put my fingers on it, I'll read some of it to you. What this bill does is what Scalia is talking about in his dissent. It's searching for evidence that someone has committed crimes unrelated to the crime of their arrest. Make no mistake about it, Scalia warned. Because of today's decision, your DNA can be taken and entered into a national database if you are ever arrested, rightly or wrongly, and for whatever reason. But the proud men who wrote the Charter of Our Liberties would not have been so eager to open their mouths for royal inspection. I would also like to bring to your attention a news article that was published, I believe last week, February 15th. It's not directly on point, but I think it is a caution for us to consider. In San Francisco, it was found that the DNA samples that were taken from victims of sexual assaults were being used by law enforcement to solve crimes. Once people's information is in a database, how it gets used will also need to be policed. I don't think anyone would want victims being treated that way in Georgia. And I realize it's not apples to apples, but it is a concern whenever we have a database of people's DNA, how and into whose hands it would fall and for what purposes. If you have any questions, I would stand for them.
Any questions for Ms. Gerton? All right, thank you.
Thank you.
Senator Tippins, if you want to come back up. I do think it'd be wise to take some of the advice from the people that spoke in the committee about looking at a minimum narrowing the felonies that are covered. You may also want to think more about the misdemeanors that you covered as well upon conviction, even if we were just to go that route and get some additional misdemeanors covered, especially certain crimes where DNA may be needed. I also think it'd be good to look at other states more. You mentioned Florida, and look at any other states that have done something similar to this, and just so we can have a comparison. But I'd like for you to get with, he's not in the room, so I'll charge him with it, Senator Watson in particular, and Senator Cowser if he's interested. You sit by him, I think, and get some more thoughts on maybe how we could do this so we could get the bill back in front of the committee.
That'd be great.
All right. Thank you.
So much. I appreciate your time.
Thank you. All right, the next bill on the agenda, we're going to skip down to Senate Bill 227. Senator Jones, you can stay in your seat if you want. Let me turn your mic on. Which number are you? Are you 4? What number are you? Is your mic? 4? All right, we're working off of a substitute, LC 490901S. And the floor is yours.
All right, thank you, Mr. Chair. So when I'm kind of looking at this particular bill, it's a condemnation bill on blighted property, which currently is allowed under OCGA 22-1-1 and OCGA 22-1-15. When dealing with condemnation, 2 issues usually come up, and so this is going to be an expanded version of it, but 2 issues usually come up. Number 1 is notice and hearing. This particular bill doesn't change the notice and hearing requirements. So the same requirements that exist now for any condemnation will continue to exist. So you still have to go through Superior Court. You still have 30 days to answer. It's the same exact notice and hearing requirements that exist. The second issue that usually comes up is just compensation. That is also not changed at all as far as doing condemnation for blighted properties. And that is found, just compensation is found in 22-1-5 and 22-1-7. That does not change. That will continue. So some of the technical aspects, whenever we have condemnation bills, one of the things that concerns is, do you have proper notice? Do you have proper hearing? That completely will stay the same. Also, as far as just compensation, a person still has to be justly compensated for the property. So what we're doing here is looking at the definition of blight. And currently, you can use the condemnation where you have blighted property. And so this particular bill looks at what we call big box retailers over 375,000 square feet. And I'll kind of say why that's important in a minute. But so the current Blight Law basically says that you can use condemnation, and of course you have to have the notice and hearing, have to have just compensation, where you have 2 factors have to be present. Number 1, and it could be any 2, but it could be uninhabitable, unsafe, or abandoned structures. Lack of ventilation, light, air, imminent harm to life or property due to fire, flood, or hurricane, and etc. It could be a Superfund site. It could be repeated illegal activity, or it also could be it's below code. So it has to be, it could be any of those 2 factors. So when you're dealing with a home, and of course this is really what this is geared towards, you may have those 2 factors. You may have where you have an uninhabited home or unsafe. You may have where you have lack of ventilation or light. Even if you're dealing with a smaller business, you may have the same thing. But what happens when you start dealing with your huge mega box type companies is they can't be allowed really to have excessive illegal activity. It would just cause too many problems. So it's almost like the county that it's located in is almost like self-defeating. So you have this empty box store there, but you can't let illegal activities go on, because if you do, that's just going to cause a major problem. So the county is going to make sure that doesn't happen. The type of businesses it is, because you're talking about usually dead malls, they can come up to code. They can keep their structure basically intact, and they can do that. But you still have this empty building. And the significance of that is this is really your mega structures. The average retail store, your Kmart, Walmart, etc., in 2020 it was 48,000 square feet. In 2019, 42,000 square feet. In 2018, it was 41,000 square feet. That's the average. So what we're talking about is basically a huge mall. We're not talking about even a Kmart or a Walmart. We're talking about these superstructures that are now sitting empty. And because of different buying habits and different things within the economy, this is something that's going to continue to grow, unfortunately, not only in Georgia but throughout the United States, to where you have these empty malls. It is predicted that by Credit Suisse that you're going to have over a quarter of malls will actually close down over the next few years. Retail will decline by 15.7%. Since 2002, department stores have lost over 450,000 jobs. That is according to Credit Suisse and also one of the leading consulting investment bank firms. Ellen Dunham Jones, who is a Georgia expert on dead malls, has stated that when you have a dead mall, the ripple effect to the community is one that cannot really be overcome. So once that ripple effect happens, it can't be overcome. So if you have a situation where you have a dead mall and the mall is acting, and you have the owner who's willing to work with the community, this doesn't need to come into play at all. But you do have situations where you have these dead malls, and you have some in Georgia which have been empty for this period of time, where the owner maybe is not being cooperative. But you have this dead store, huge mega structure that's not going anywhere. And it's not just taking down the immediate area, it's taking down the whole area that it's located in. And when you have that situation, what we're trying to do here is just give the municipality another item in their toolbox to basically be able to work with these particular owners. And this just gives them the opportunity. It doesn't mandate that they use condemnation at all. It just gives them the opportunity. One of the criticisms about any condemnation law is that it's subjective. What we've done here is actually make it more objective. It only applies to those 375,000 square feet. It's only going to apply if you're going to be empty for 10 consecutive years or less than 30% occupancy for 20 years. So we actually really making it extremely tight. To contrast it, New Jersey has a similar law, and they say it only has to be, your commercial store only has to be empty for 2 years. So what we're doing is we're looking at those actors or those persons that really are not even attempting to improve that particular superstructure. It's sitting there empty, and it's taking down the remaining community. And this just gives the municipality, under those circumstances, an opportunity to have an extra tool in their toolbox to be able to negotiate and find out what that just compensation is, and to be able to work with these particular owners when that situation happens. And it really is going to be, you're not trying to demonize anybody, but it's going to be more of your worst actors that are there that own these particular properties. Because you have some malls that are actually trying to find ways to encourage economic development, but you do have some, one located in Augusta, for a matter of fact, which has been sitting dormant for almost 20 years. And it fits this, and it's actually 800,000 square feet. But you also have them in other places in Georgia too. Macon Mall, I think, is 70% unoccupied. You have the North DeKalb Mall, which now basically is doing things as far as movies and entertainment is concerned. But you have also, this will affect more than just Augusta. And the problem is that it's something that's going to continue to grow. And there's really not anything that we're going to be able to do about it to change it. So you have to change the character of these particular businesses. And this gives the opportunity to do that. And that's what this bill basically is. And I'll open up for any questions.
Senator Kirkpatrick.
Thank you for bringing this. We've got this situation in Cobb County with a blighted area that unfortunately was a big mall-size area, but it had a cemetery in the middle of it, a family small cemetery. And so that area sat there, and in fact is still sitting there for 20 years. empty, and you're absolutely right about the impact on the community. Finally, the county, through a lot of difficulty, was able to navigate it and find a developer who was willing to work around the cemetery, because the family refused to let anybody be moved out of the cemetery. And so that process is now underway. And if your bill would do anything to alleviate that, I would certainly be supportive. Have you run into that situation?
What we're running into in the Augusta area is just we've tried to put that mall, make it into a James Brown arena, but the deal was so bad we couldn't go forward on it. We also wanted to put government complexes there, but once again the deal was so bad that we couldn't move forward on it. And so we have an 800,000 foot superstructure that's just been sitting there. And if Gwinnett also had a similar problem with their mall, their county purchased it under the normal kind of way you do things. And they're sitting there, and that's why you also have federal legislation that just got introduced to help with grants as far as financing this. Gwinnett bought it for $23 million, which probably was overpriced. One of the things about your malls, your dead malls, if you look at the experts, they say the number one thing you do not want to do is pay too much for it, because to actually try to improve them costs a lot of money. So Gwinnett bought the mall, and because I guess they were at their wits' end, but now you see federal legislation which is directly really related to that situation, where they probably paid more so than what they needed to at $23 million.
One question I had, you have on line 16 was built prior to 2000.
Yes.
Do we want a year like that in there? Because in a few years we come back and say this one was built in 2002, yet the law doesn't allow. I mean, is there any thinking as to why you want that in there?
What I was really trying to do was kind of use those structures that exist now, that are there, and some of the ones I named were built in 1965. Ours is built in 1980, because I really didn't want to necessarily try to include persons who are just starting out. So that's why I was trying to tighten it up to where we're not trying to say, hey, this may have just gotten empty and you're still trying to do something. So make it 2000 to where, no, it's really been sitting for a while, because I don't want it to be too broad is what I really was looking at. So I understand what you're saying, but I'm actually trying to make it to where it's not so broad to where we're putting pressure on the owners to where they have to do something immediately. This is those folks who have really been out there for years not doing anything.
All right. Senator Kennedy?
Mr. Chairman, Senator Jones, thanks for describing or explaining the bill. So a couple of questions. So what happens, or what can one do once the definition of blight has been met? Is that what section I at line 78 provides, or is there more to it than that? I was just reading the bill, admittedly, during our hearing, and so I kept looking for, okay, because the majority of this goes to the definition of blight and what meets those metrics. And then so the question I have is, with your idea and what the bill is supposed to do, once that's been determined, what then does that afford a municipality?
What this really does, the only true change that it does, because currently this bill really reflects current law, which is 22-115 and 22-11. Under current law, you can condemn for economic development purposes, and it describes, if you look at line 21 through 26, it describes what economic development purposes are. So you can do that today, but that usually applies just to like homes or regular businesses. But you have to satisfy the blight definition. What this law really does is just change the blight definition. So you can use, so what it does by changing the blight definition, because these big box retailers, they're not fitting the blight definition, it's only now changing that definition and allowing you to do what already exists today, which is located on line 21 through 26 and also on line 28. So this is what we have today. Today, when you declare something to be blighted, you can use it for economic development. You can condemn for economic development purposes, and you see how that's defined. And also, when you declare something to be blighted, you can condemn for public use, which means the remedy of blight when economic development is a secondary or ancillary public benefit of condemnation. That's today. That's right now. What
that-
we're trying to do is, go ahead.
Is that language found somewhere else in the code? Because you're saying that's what's today, but that's new language in this bill.
I think because the bill itself is new language.
Well, I mean, lines 21 through 27, if I'm reading them correctly, are all underlined. That's red
Yes.
line, new language.
Right,
So-
because the bill itself is new, but if you go to 22-115, that's
Okay.
where it's located, which is condemnation for public use, petition, notice, and order. And I do know that it's underlined, but if you look at 22-115, it's that language. When you find something to be blighted, 22-115 and that's why this code section is 22-116.
Okay.
When you find something to be blighted, this is what you can do.
And so once that definition has been met, even if it's the same definition that we've got in code now, I'm sorry, help me understand, what is it that the municipality can do once that's met?
Right, so the municipality-
That they cannot do now? What remedy are you affording cities that they can't do now?
What they cannot do now is that you have to first determine that it's blighted property. And on these big box properties, you're not really fitting the definition of blighted property. So you can't do what's in 22-115. To get to 22-115, you first must say it's blighted. And remember, to be blighted, it has to be abandoned. Well, I don't know if you necessarily could say it's abandoned. It has to be two things. Number one, it has to be abandoned. Then it has to be basically a health hazard, or it has to be a criminal hazard. And the point being that these big properties, they're taken care of from that standpoint. They're not going to be, they can't be adequately said to be abandoned because you have an owner. They're not going to have huge criminal elements because they can't. The county itself is going to make sure that you don't have a whole huge criminal problem because you have this 800,000 foot structure. We're not going to have a criminal problem. The business itself has enough money to bring it up to code. So you can't declare it under the current definition as blighted property. So what this law does, it says, okay, if you're 375,000 square feet and you've been vacant for 10 consecutive years, or you've had 30% occupancy for 20 years, under those circumstances, you'll be declared to be blighted property. And then what we can do today, 22-115, kicks in.
And that is what, condemnation?
That's correct.
And then the county or municipality would condemn the property?
Correct. Well, yes, but you don't forget now, they still have to go through the same notice and hearing procedures.
No, I understand
Absolutely,
that. I'm just
right.
wondering, so
That's
let's
correct.
unpack that a little bit. What happens next? If it's then condemned, then there's a determination as to the fair market value,
That's correct.
and the money comes from the county or city coffers?
Right, because, but remember, the county would have to make that determination that that's the route they want to go. And just like any other blighted situation, they would have to pay just compensation. That's not taken away. But just compensation is the key, not $50 million for a property that's really not worth that. So, and that will be up to the county to make that determination. They'll have to go through that process, and that's why I say it's just a tool in the chest. They could make a determination it's not worth doing this. They could make that determination. But right now, they really can't even make that determination because the definition of blight is not going to fit that particular store in most instances. It's going to be empty, but it's not really abandoned, and all those other factors are not going to be there. But yet, this superstructure is taking down that whole community. It's impacting that whole community, and it doesn't stop impacting that whole community. And the county is like, well, what can we do?
So
And
it
so what
sounds
happens is the county, like in Augusta, the county is running around trying to find code violations and things of that nature, which may or may not exist. And then you have this kind of battle that goes on of what's code violations and things, when in reality, if you just change the definition of it, the county can say, you now fit this new definition of blight, and then they have a choice to go forward or not. They don't have to, they have that choice.
So it sounds like the heart of this really is what you're describing is what I suppose would be line 21, economic blight,
That's correct.
as
Which
applied
is,
to this mall type environment.
right, which
Versus
exists
what
today.
most of us think of when we hear, at least me, when I hear blight, and I know Macon has been having to deal with this and trying to figure out a way to deal with blight, but it's in the residential areas
That's
where you
correct.
have housing structures.
That's correct.
And okay,
So this here actually fits a commercial structure more so than houses. So we allow us to condemn homes, a person's home, even though they may be living there and things of that nature, but it's still local homes. We can do that, but we're kind of like leaving the superstructures alone. This only says now we're going to bring that into play too. It doesn't give the county any more rights than that exist today. It doesn't give them any more what they can do economic development that exists today, and that's why you need to look at 22.
But it would be more
115.
rights over this type of property that
It would
does
be
not
more rights
exist
under this
today.
type of property,
In fairness,
correct.
it would be.
No, that's
it would have
correct.
an application here that doesn't have otherwise.
That's correct, but it
Yeah.
wouldn't change the economic development definition, and it doesn't change the public use definition. That's the same definition that we use today. It's not like we're expanding those definitions. We're just
Right.
expanding the definition of blight.
Okay. Thank you, Mr. Chairman.
Senator Rhett?
Thank you, Mr. Chairman. To Senator Kennedy discussion, when it comes to homeowners' personal property tax, trying to determine blight, I know in Cobb County some years back, if the house wasn't kept up to code and they were notified, then they had what they call a blight tax, where they might increase the property tax 2 or 3-fold until they brought it up to code. Just something to think about. But I was going to ask the senator here a few questions, but I thought he did a pretty good job at defining blight from an objective manner and not from a subjective perspective. Because I remember years ago I talked with the commissioner and I asked him, how do you know an area is blighted? His response was, I don't have a definition, but I know it when I see it. That was too subjective, but.
Senator Parent?
Thank you, Mr. Chairman. Senator Jones, just out of curiosity, what is your research and work on this demonstrated about the owners? Why are they not willing to sell? Are they just hoping to hold it to appreciate?
So that's possibility. So what you have, and you've had this in not only in what we call the Regency Mall, but you also have it in a couple of malls in Georgia, multiple owners. So you have an ownership group, because these are not like single owners, these are ownership groups. These are persons who actually are designed to quote unquote fix up malls. So you have an ownership group, they'll buy, and then they can't do anything with it, and then they'll sell to another ownership group. And it just continues to go forward, and nobody does anything with it, and the county is just sitting there, and the whole area just continues to go down while they're negotiating whatever price they want to try to negotiate with. And so that's what takes place. It becomes part of and I'm sure smarter people can do it more than I can, but it becomes part of just a portfolio that they have within their kind of economic investments, correct?
Okay, thank you.
Any other questions for Senator Jones? All right, no one else has signed to be heard on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Rhett. Do we have a second? Second. Second by Senator Parent. Do we have any discussion?
Mr. Chairman,
Yes, sir.
Yeah,
Senator Kennedy.
as I said in my remarks earlier, admittedly, I'm absorbing this during the hearing. I'd like to see us think about this a little bit more. One of the concerns I've got, Senator, is what happens when you've got someone who owns a piece of property that they either owned it previously or they bought it after it went dark, but they're speculating on it on the long term, and it's not causing the type of blight that we think of. It's not having the ripple effect, but it meets the metrics. And what you've done now, or what we might be doing, is shifting that decision-making authority, which in Georgia we're pretty particular about respecting property rights, from the owner of the property to some locally elected officials. I'm also concerned about how the statute might be used in a way for local well-intended officials to start telling property owners, well, you need to do X, Y, and Z to improve the looks of this or improve that, or you better get some tenants in there, or we're going to have a blight determination on you, and you may wind up losing this property. It may be property that's been in that person's family for generations. I'm just trying to think through this. I've got my request of the committee would be that we hear it today and then allow some time to think about it. Those are some of my concerns.
All right, Senator Hatchett.
Yeah, and I hope this isn't out of turn, but something he just said brought a question to mind is, in the definition of a blighted property, and Arthur, if you could answer this, is ownership a part of that equation? Meaning, let's say it's been empty for 9 years and someone buys it, so that it actually transferred owner, and that this person's only owned it for 1 year. Could it still then be considered blighted because it's been empty for 10, but the new owner has only owned it for 1?
Yeah, I think.
Wait, get your mic on.
I think under the current law, that probably would still be the case, but there are other areas dealing with the condemnation that kind of address that, and we can go back and look at that, because the condemnation law is over 50 sections, quite frankly.
Okay.
So there's other areas that kind of deal with that, because you'd have the same thing with a home. You'd have the same kind of issue with a home. But in this situation, of course, that would have to be something that company, because we're talking about companies, we're not talking about something that's in someone's family, quite frankly. It's not feasible. I mean, I guess it is, but it's 375,000 square feet. So it's it's huge. I mean, it's not a small, it's not a small structure. Like I say, it's not even a typical Kmart. That's like the biggest, your super Walmart's like 100,000 square feet. So it's not even that. So I think that's something that they would have to take into consideration if it had actually been vacant 100%. And that's one of the key things. That's 100% vacancy. Now, if you get up to like 30% vacancy, then there has to be 20 consecutive years. So we're talking about 100% at the 10-year level. That's what we're talking about there. And that's why I actually put in the 2,000, so it really wouldn't impact someone like that. The 10-year level would, but when you start talking about less than 30%, it has to be 20 years. So they would just be coming up on that today. So if I said, okay, it has to be built prior to 1985 or something, that would be totally different. But using the 2,000 metric is why I did that. So it wouldn't necessarily catch somebody in that particular situation.
Okay.
It gives persons much more time to deal with it.
Senator Rhett.
Thank you, Mr. Chairman. I think the senator said that they would be offered fair market value, right?
What happens is you have just compensation, and there's negotiations, and this is all within statute, so it's not like just I'm running off my head. So within the statute, it can be just compensation. If you can't come to an agreement, then you go to this other section of the statute, which is basically, I think, more fair market value. That's correct. There is a negotiation process that's taking place here. This isn't just grabbing property, and that's through regular condemnation law.
Any further discussion on the bill? There's been a request from a committee member to hold on the bill, but there is a motion to pass pending. Would you?
Mr. Chairman, I make a motion to table.
I believe that the motion to pass takes precedence over the motion to table.
Motion to table takes precedence.
Yeah, I think so.
Or I was going
I
to
think
ask
table.
if the senator wanted to withdraw his motion to pass, and let's.
But he would have to withdraw it.
Yeah, you want to withdraw your motion to pass?
Yes, sir, Mr. Chairman.
Okay, it'll have the same effect. So we will get answers to those questions then and put you back on for another hearing.
Okay.
All right? Thank you.
Mhm.
We have one bill left on the agenda that's my bill. I'm going to ask Senator Cowser to come sit here. That way you can control this. I don't know if we'll have time to hear from everybody. I can go ahead and present the bill because we do have a hard stop at 3 o'clock. Introduce your judge, too.
First course of business is I'd like to introduce Judge Lawton Stevens from the Western Judicial Circuit. Good to have you with us. You gonna just I was looking to see you show up down there. Okay. Senate Bill 501, Senator Strickland, you
I'll just sit here if that's good with
recognized
you.
from that seat. Yes.
All right, Senate Bill 501, working off LC 490822. In this bill, you'll see the current law in looking at a sentence that's been imposed gives the court discretion within 1 year of a sentence being imposed on an individual or 120 days after the remittitor is filed, affirming a judgment on appeal, to go back and reconsider a sentence. And that's done, as you see in current law, lines 19 and 20, is something that the defendant has to file a motion requesting. So the motion a defendant can go back and file and ask within a year for a sentence to be looked at again. What we're doing with this bill is adding another opportunity for a sentence to be revisited, but this time it's by a prosecutor. And so you'll see lines 22 through 33. This bill would set forth the process where a prosecutor could at any time, there's no restriction on the amount of when this would happen, ask a sentencing court, so the court that actually sentenced an individual, to revisit a sentence when someone is still incarcerated. And you'll see the standard that's put forth in here, looking at on lines 24, the interest of justice not be served by the defendant's continued incarceration. And you'll see that what the court's to look at, lines 27 and lines 28, are post-conviction factors. The story that was given to me from some prosecutors is sometimes there's that case that haunts you, kind of keeps you up at night. You think maybe we didn't get this one right. Maybe there's some things that have happened since conviction, whether it be some other evidence has come forth, maybe some other change in the law or some other facts given an individual that's sentenced. They want a second shot as a prosecutor in going back and asking a court to revisit a sentence and see if someone should still be incarcerated in the future. And so with that, Mr. Chairman, there are some folks who want to be heard if we have time to start any speakers. Otherwise, I'd be happy to answer any questions anybody has.
Any questions by committee members? All right, seeing none, we'll hear from anybody that signed up to speak.
Sign-up sheets from
All
Friday.
right. Who's that? Rita Rocker from Pardons and Paroles.
Hey, Mr. Chairman, I'm going to defer to the DA, Jerry Lawton.
Okay.
We've come to some agreements, and we have no issue with this legislation.
That'd be great. Ms. Boston, come forward. I'm trying to hold you to about 2 minutes, if that's okay.
I'll hold it even shorter.
Right.
I just thank you so much for hearing this today. This legislation is supported in full by the District Attorneys Association. I have spoke with the Board of Pardons and Paroles. They did have some questions about whether there would be fiscal concerns about the passage of this legislation. And after speaking to myself and also a representative from the Fulton County DA's office, which represent the two largest jurisdictions, they are satisfied that the numbers are not going to have any fiscal responsibility or fiscal concerns for that agency. We don't see this as a large number of cases, but we do, as Senator Strickland pointed out, see this as an opportunity to correct injustices, where decades later, with new information, changes in the law, that we can do the right thing. And so this is a tool to give our prosecutors the opportunity to stand in justice and do just that. And so I'm happy to answer any questions, but welcome the support of the committee.
Just one from me. Do you perceive this to be used more in circumstances if there's been exonerating evidence or something that came out later, or when the laws, let's say we decriminalize marijuana, you want to let people free that had been convicted previously for something that's no longer a crime?
So this would not be exoneration. If someone is deemed to be innocent, there are absolute vehicles for the discovery of new and exculpatory evidence. And there are already vehicles to make sure that folks can get before a court for those issues. These types of cases are where someone is absolutely guilty and there was culpability and they've gotten a sentence that now, some decades later, perhaps with new information, it's been perceived that incarceration for an excessive amount of time is no longer warranted. Or, Senator Cowsert, as you pointed out, if the law does change and no longer in 2022 or 2023 would we have that same punishment, we don't want somebody that was sentenced back in 1974 not to have the opportunity had they committed that crime currently.
Okay. Senator Kennedy, you're recognized for a question.
Thank you, Mr. Chairman. Hey, Ms. Boston, good to see you.
Good to see you, Senator.
So in reading this, one of the questions that popped into my mind was sort of the circumstances you were talking about, which raised in my mind the 2020 stories that you see on television, where the prosecutor says, yes, I prosecuted, but I've been haunted by it, either since the prosecution or 10 years later learned something and I've been haunted by it. But I don't see that consistency of the characters, if you will, that were involved in the prosecution being required here. And what I mean by that is I don't see where the language says, for example, it doesn't have to be the same district attorney, does it?
No, it does not.
It doesn't have to be the same prosecuting attorney, does it?
It does not.
It does not have to be the same judge that presided over the first case, such that he or she, as the judge, could recognize the great differences of what existed at the time of conviction compared to 2 years, 10 years later.
Correct.
Are you concerned at all about that lack of consistency of the people that were involved? Because, as I said, what pops in my mind is sort of the example you gave when you said, here's the typical example. But I'm concerned about a disconnect such that if you have someone who was not involved at all and that maybe has a very different mindset about even following current Georgia law and decides to utilize this for purposes that is not what you're describing and, quite frankly, what we're probably all thinking about.
That's an absolute fair question, and let me just answer it this way. When we're looking at these types of sentences, some perhaps 20 and 25 years later, it's very unlikely that any of the players will be the same. I don't think anyone 25 years from now, I don't plan on still be sitting in the district attorney's office, but I do want that DA have the ability to see and learn the new information that we do learn as we evolve over 25 years. But let me say one thing that doesn't change, and that is the right for the victim or the next of kin to be heard. And I've worked on a couple of these cases and where the judges weren't the same and where the district attorney is different. But I can tell you in the last case I worked on, the former district attorney in that case, J. Tom Morgan, wrote a letter asking me to consider this. And the assistant DA that prosecuted that particular case under J. Tom also asked me to consider it. So I will say we have seen where the elected and even the assistant DA, who's probably now moved on to make a whole lot more money, has weighed in consideration on individual cases. And we can still reach out. We're not required to. But I can tell you, as someone that has looked at these things, we look at them very carefully. They're not decisions made overnight. We talk to as many people as possible, including examining the current record and talking with the board, with the Department of Corrections to find out what's happened as well.
Mr. Chairman, one follow-up.
One final.
To that last point you made, Ms. Boston, is there something in the law that allows some version of this now for district attorneys?
No, which is exactly why we're hoping that you will support this legislation. Right now, a defense can always file a motion in court on behalf of their client. The prosecutor has no current vehicle when they're standing as the minister of justice to be able to bring this motion. So if, for example, I thought justice demanded it, I couldn't even bring a motion in court as the minister of justice. I'd have to rely on a defense attorney or a legal organization to bring a motion on behalf of a defendant versus me standing as the district attorney before the court saying that justice demands me make this request on behalf of the state of Georgia.
Thank you, Mr. Chairman.
Senator Hatchett, if I could get you to ask a quick question, and that we did want to hear from Maisie Lynn, if that's okay with you, Mr. Chairman, at least complete our testimony on your bill.
Hey, I just have two quick questions. Number one, with regards to, I guess, the Deal administration and the criminal justice reform that was passed during his time in office, I guess the doing away with certain mandatory minimums, is this a vehicle now where someone could go back and say at the time there were mandatory minimums, there aren't mandatory minimums now, and they could file, is this a vehicle they could use to potentially decrease their sentence based on the changes of laws just centering around the mandatory minimum sentences?
This vehicle could only be a motion made by a prosecuting attorney. But in answer to your question, if mandatory minimums did change, then yes. But if there was, it gets confusing because I'll say this, is that if someone's serving a sentence under an old mandatory minimum, they are not penalized when that changes moving forward and giving more time, if that makes sense. But what we have seen is that as mandatory minimums have changed, where if someone today would be given less time, then this would be an advantage to a vehicle by a prosecutor to remedy that lack of retroactive status, if I'm understanding your
No, that's,
question
you
correctly.
answered that right on. That's what I wanted to hear. And then the second question, Mr. Chairman, if I can. I see on line 36, it says victims shall be afforded all rights as outlined in Chapter 17. Just above that, talking about what can be considered by the sentencing court, there's a list of things, but victims' testimony or testimony from the victim's family is not included in that. Could you just explain to me, does paragraph 4 allow for the victims to present evidence, I guess, in opposition of any decreased sentence?
Yes, the current Victim Bills of Rights requires any court to allow a victim to make an impact statement and offer evidence and information.
Okay.
And that we just reiterated that this type of hearing, those rights that already exist absolutely carry over into this hearing as
Okay.
any other.
Thank you.
Maisie Lynn, would you like to be heard really briefly so we can free up the room?
Thank you so much for letting me squeeze this in. Judicial supports this legislation. I've spoken with Ms. Boston and with Chairman Strickland. We have a friendly amendment to offer, and the basis of it is that we're looking specifically at lines 25 and 33. And the idea that justice would not be served by the defendant's continued incarceration. Because this bill contemplates defendants being released from custody, which we are all for, that language is sufficient for that. But we would like to add under the current sentence, behind each of those continued incarcerations, under the current sentence, because we believe that would allow clarity around resentencing when the person wouldn't be immediately released from custody. There are situations where I was speaking with one of the representatives from Fulton County earlier today, where someone might have been given, let's say, a 15-year sentence, and there's a will to reduce it to 10. But there's still time that they have to serve in order to even serve that 10. So our language would allow for the spirit of the release, but also allow for lesser sentences where someone's not being released. And also, I think important to note, it would not open the door to probation modifications. We're still dealing with only incarcerated people.
Questions? All right. Thank you so much
Thank
for being
you.
with us today and sharing your thoughts. Mr. Chairman, you want to take action or clear your room and
No, let's
consider that later?
work, a couple of things have been brought up by the committee, and then so we can clear the room, I'll get this
All right.
agenda.
In that case, we're adjourned. Thank you.
Thank you.